This is Anand Kumar, Assistant Professor from School of Law, Satyabama Institute of Science and Technology. In today's session, we are going to discuss about an important concept in the Competition Act 2002, which is anti-competitive agreements. So, the anti-competitive agreement is an important concept in the Competition Act because it plays a vital role in determining the offences that happens under anti-competitive aspect. So, we have few contents which is necessary for understanding the whole concept of anti-competitive agreement. So, we have definition part, nature, classification, exemptions, grounds for inquiry, procedure for inquiry, and the final thing is penalty. So, all these 7 parts are most essential to understand the whole concept of anti-competitive agreements. So, for this understanding, we have few set of sections which is following the next slide. So, here comes the sections. So, now we have section 3, section 2c, section 19 subsection 1, section 19 subsection 3, section 26 and section 27. So, all these sections are more relevant to understand the whole concept of anti-competitive agreement. So, to begin with section 3. Section 3, this speaks about the whole concept of anti-competitive agreements. Now, this section 3, it carries 5 different subsections. Subsection 1, it reads that any agreement which has a tendency or which causes an appreciable adverse effect on competition is called as anti-competitive agreement. I will repeat the term again. Any agreement which has a tendency or which causes an appreciable adverse effect in a market is called as anti-competitive agreement. Now, here the definition is not expressive, it is inclusive in nature. So, in order to identify the whole status of anti-competitive agreements, we are referring all these provisions. For example, section 19 subsection 3, where the grounds for anti-competitive agreements were being highlighted. So, section 3 subsection 1, it clearly reads that any agreement which has a tendency or which has a nature to affect the market, that is appreciable adverse effect on competition, then such agreements are called as anti-competitive agreements. Second, in section 3, we have few other subsections such as subsection 2, subsection 3, 4 and 5. Subsection 2, it declares that any agreement which causes an appreciable adverse effect in a market, it declares to be void. And the subsection 3 and 4, which speaks about the different kinds of agreements, whereby the anti-competitive agreements can be classified into 2 different classifications. One is horizontal agreement and the other is vertical agreement. So, under the horizontal agreement, we have 2 different offences to be listed, which is cartel and bid rigging, and on the other side vertical agreement, which is dealt under section 3 subsection 4, which can be classified into 5 different categories. One is tie-in arrangement, the other is exclusive supply agreement, the third is exclusive distribution agreement, refusal to deal, and the final is resale price maintenance. So, the horizontal and vertical agreements were being classified as per the performances in the market area. So, now when it comes to horizontal agreement, this agreement means the agreement which is concluded between same set of producers, same set of manufacturers or same set of distributors in order to restrict competition in the relevant market. And when it comes to vertical agreement, the agreement is concluded between different set of producers, different set of manufacturers or different set of other set of suppliers. So, all these things forms a part of vertical and horizontal agreements. And finally, when it comes to section 3, we have an exceptional part where section 3 subsection 5, it deals about the exception. So, under this section 3 subsection 5, we have 2 exceptions, whereby the first one is export rights. When an enterprise or when a company does a job or a business of export, then such export rights will not be termed as anti-competitive agreements for the purpose of section 3. And the other exception is intellectual property rights. Under intellectual property rights, we have 5 different rights that are protected under the intellectual property law. One is patent, other is copyright, trademark, geographical indications, designs and few other rights. So, all these rights are already protected by intellectual property laws, and those rights cannot be treated as anti-competitive agreements for the purpose of section 3. So, all these 5 subsections are most important to understand the whole nature of anti-competitive agreements. Second, I have included section 2C, which means that cartel. So, here the cartel is one of the offence which is booked under the anti-competitive agreements. Now, the cartels are agreement which is concluded between enterprises for the purpose of limiting the production and excluding the competition in the relevant market. Finally, I have included few other provisions whereby section 19 subsection 1 it deals about filing of information. What is filing of information? So, now when it comes to filing of information, unlike other cases, here the filing of information is most important part, whereby an enterprise who wants to file a complaint against the other enterprise, then they can file an information, and based on the information the Competition Commission of India can take action on its part. Next, section 19 subsection 3. Section 19 subsection 3 it reads out the grounds for determining the offence, that is the offence of anti-competitive agreements. Now, under this section 19 subsection 3, we have 6 different grounds whereby an anti-competitive agreements can be proved in a market. Next, section 26 which speaks about the procedure for inquiry. So, soon after an application or an information is filed by an enterprise under section 19 subsection 1 of the Competition Act, the Competition Commission of India it can take cognizance of the said offence, and it can appoint a Director General for the purpose of investigating or inquiring the said anti-competitive agreements. So, the procedure it has an enlarged procedure. So, this we will be discussing in the later part. And finally, section 27 which deals about the penalty. Now, when it comes to penalty for anti-competitive agreements, now the Act it declares that the penalty can be 10% of the average turnover or 3 times of the profit which the company has earned or the enterprise has earned for the previous 3 financial years. So, this is the penalty part with respect to anti-competitive agreements. Thank you.